Iowa has a well-structured approach to habitability that gives both landlords and tenants clear expectations. The state's landlord-tenant law is found in Iowa Code Chapter 562A, the Uniform Residential Landlord and Tenant Law, and it lays out habitability obligations in a straightforward manner. Under Section 562A.15, Iowa landlords have a detailed list of obligations. You must comply with all applicable building and housing codes that materially affect health and safety. You're required to make all repairs and do whatever is reasonably necessary to keep the premises in a fit and habitable condition. Specifically, that means maintaining the structural components in good repair, keeping plumbing systems working with hot and cold running water, ensuring electrical systems are safe and adequate, providing heating facilities capable of maintaining adequate temperatures. And in Iowa, where winter temperatures routinely drop well below zero, this is non-negotiable. Maintaining any air conditioning system supplied with the unit, providing working smoke and carbon monoxide detectors, keeping common areas safe and sanitary, supplying adequate trash receptacles, and providing running water and reasonable amounts of hot water at all times. What's notable about Iowa is how the statute handles the balance between landlord and tenant responsibilities. Section 562A.17 spells out the tenant's obligations with equal clarity. Tenants must keep the premises clean, use fixtures properly, dispose of trash, not damage the property, and comply with health and safety codes. Iowa courts look at both sides when evaluating habitability disputes, and a tenant who caused or contributed to the condition may find their remedies limited. Iowa's repair process follows a structured notice framework. When a habitability issue arises, the tenant must give the landlord written notice identifying the problem. For non-emergency conditions, the landlord has 7 days to make the repair. That's a shorter window than many states, which typically allow 14 days or more. For emergency conditions that pose an imminent threat to health or safety, the expectation is immediate action. If the landlord fails to act within the 7-day window, Iowa gives tenants a clear set of remedies under Section 562A.21. The tenant can pursue damages in court for the landlord's non-compliance. They can obtain a court order requiring the landlord to make repairs. They can seek rent abatement reflecting the diminished value of the property. And if the non-compliance is material and affects health and safety, the tenant can terminate the rental agreement after providing proper written notice. Here's something that makes Iowa interesting. The state does not have a statutory repair and deduct remedy for most situations. Tenants cannot generally make repairs and deduct the cost from rent. However, there is one important exception. Under Section 562A.23, if the landlord deliberately or negligently fails to supply essential services, defined as heat, running water, hot water, electricity, gas, or any other essential service, the tenant has additional options. They can procure reasonable substitute housing during the period the essential service is unavailable and deduct the cost from rent. They can recover damages based on the reduced fair rental value. Or they can procure the essential service themselves and deduct the actual cost from rent. That essential services provision is a powerful tool that Iowa tenants can use, and it incentivizes landlords to address critical failures quickly. Ignoring a tenant without heat or hot water in Iowa can get expensive fast. Iowa's farming heritage creates a practical consideration that landlords in rural areas should understand. A significant portion of Iowa's rental housing is in small towns and rural communities where local code enforcement may be minimal or non-existent. But the absence of local code enforcement doesn't reduce the landlord's obligations under state law. The implied warranty of habitability and the statutory duties under Chapter 562A apply everywhere in Iowa, regardless of whether there's a local inspector who might knock on your door. Iowa's anti-retaliation protections are found in Section 562A.36. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant complaining to a government agency about code violations, complaining to the landlord about habitability issues, or joining a tenants organization. If the landlord takes adverse action within 1 year of the tenant's protected activity, and that's one of the longer protection windows in the country, there is a rebuttable presumption of retaliation. For the complete guide to Iowa's habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Guide series.